afternoon, everybody. Here we are again for a new talk on international tax issues. We are pleased to have our host here today, Mr. Mukesh Butani from India. Mukesh is a tax partner of BMR Legal, one of the leading law firm in New Delhi and in India. And it's important because we want to understand also what is happening in India from a tax perspective in this period of emergency. So thanks, Mukesh, for this important explanation.
Thank you, Luca, for inviting me, and I'm extremely delighted to talk to you. Well, I would just like to talk about two aspects, important aspects. One, immediately after India went into a complete lockdown, the Indian Parliament session was currently underway, and the annual finance bill of 2020, which was presented on the 1st of February, was being debated. It got passed in the Parliament a few days after the national lockdown. There are some changes in that bill which may be of importance to our viewers, and I just wanted to talk very briefly about that. The first change is that India in 2018 had legislated the significant economic presence test in its law. That was not implemented because the administrative guidance and the subordinate legislation was not announced. So when in 2020, India took a decision that it is going to defer the implementation of significant economic presence to April 1, 2021. So that came as a good news. But to some extent, that good news was neutralized because when the 2020 bill was passed, the lawmakers inserted expansion of the equalization levy. This is like the transaction tax on digital transaction, which has been a subject matter of debate in many parts of the world. Now, India had equalization levy as being amongst the first countries in 2016, except that the equalization levy of the 2016 was restricted to application on B2B transaction, and that too in particular for the advertising transaction. Now, the expansion of the law in 2020 is different. It extends to B2C transactions. It is very widely worded and expanded. Just briefly talking about it, it says that equalization levy will be levied now on all non-resident e-commerce players, including the intermediaries who have a role to play in the e-commerce transaction. Incidentally, this law is applicable from April 1. Many of the e-commerce players have been taken by surprise with the law for a variety of reasons. Number one, after the 2016 equalization levy, there was no expansion of this law. Number two, this law was not what was originally proposed in the February 1 budget. It got passed when the country was already in a shutdown mode. This law mandates now that from April 1, e-commerce transactions will be liable for the equalization levy. Now, the law is very briefly worded. It doesn't have subordinate legislation. So though the Department of Revenue has indicated that it is going to come out with a Q&A to clarify the various facets of the law is applicable as of today. That is a surprise that has come in. The law has been very widely worded. It covers goods, services, and it covers not just e-commerce operators, but also intermediaries, as I'd mentioned. So that's a very, very important change. So let me pause over here to see if there are any questions before I get on to what are the specific measures India has taken in relation to the COVID-19 health crisis.
Thank you.
No, thanks. Go ahead. Thank you very much. Really clear.
Yeah. So coming to COVID-19 health crisis, the most important change has been that India has passed an ordinance. It's called the Taxation and Other Provisions Relaxation of Certain Provisions Ordinance 2020. As the ordinance suggests that there has been no fundamental shift in the tax policy like in other countries by way of reducing the tax rate or so on and so forth. These are procedural changes in the law. The three most important procedural change in the law is number one, relief measures have been announced as regards the statutory and regulatory compliances on a host of tax matters. Two, extensions have been provided for in a host of tax and related tax laws. And three, more importantly, there is a special fund that has been set up called the Prime Minister's CARES Fund, and this fund is to be able to provide relief to people who have got affected through the coronavirus. So those are the three important measures that are there. Now, just in terms of extension of the deadline extension is applicable for all tax returns that were due for filing on March 31. Those dates have been extended to June 2020. The statute of limitation on filing belated tax returns for past years have been extended, and similarly, the statute of finding for filing the revised return has also been extended. On the issue of giving relief to the Indian middle class people, there are some important relief measures, and those have been for small businesses and individuals. For example, if you have a tax refund up to ₹500,000, which was not processed by the tax authorities, those refunds have been processed, and about 1.4 million taxpayers have been benefited. A similar benefit has been granted with respect to 100,000 small and medium business enterprises who were expecting to receive a GST and customs refund. It has been announced by the Ministry of Finance that the total refunds that have been granted are about 180 billion people. The intention is very clear. These refunds will alleviate the difficulties of the small and the marginal taxpayers and the businesses. There are other benefits that have been granted. Normally, India charges between 12 to 18% interest on a host of delays in relation to payment of advance taxes or withholding taxes, so on and so forth. So what they have done is that those 12 and 18% rates have been rationalized to 9%. So if you're delayed in payment of taxes or if for any reason you're unable to meet your withholding requirement, then those interest rates will go down to 9%. And they have also prescribed that we will waive off all the penalties and late fees just because you are delayed in discharging your tax obligation. Frankly, those are the most important changes that have been brought about insofar as the extension is concerned. Another important change is that India legislated a dispute resolution law to settle all forms of direct tax disputes. And this legislation was announced on the February 1, but passed in the parliament immediately after the lockdown. And now this was supposed to be a window that was opened till 31st of March in certain cases and 30th of June in certain cases. Now that window has been extended to 30th of June. So taxpayers now have more time to make an informed call whether they want to be a part of this process or not. There are other benefits that are announced in the context of filing of the GST returns. the last date for filing of the returns for the month of April and March have been extended till the 30th of June. And similarly, the last date for filing the annual returns on 31st of March have been extended to 30th of June. There are many other benefits that have been announced in the context of GST law. And again, if you look at these benefits, they are more or less like the Income Tax Act. For example, if you have a turnover less than 50 million rupees, then no interest, late fee or penalties. If you have a turnover above 50 million rupees, then reduced rate of interest will apply. Instead of 18%, 9% will apply, and there is no case of any penalty. So those are the other changes that have been brought about. There are similar changes on extension of compliance due dates under the GST law, and a host of small other changes that I don't want to get into. But I just wanted to find out, also talk about some important changes in the area of dispute resolution in COVID times. And this dispute resolution in COVID times has got to do with how our courts will work and how our tribunals will work. So insofar as the courts are concerned, they have issued guidance, including the federal court, that they will hear only what they call it as an extremely urgent matter. And they have defined what extremely urgent matters are. These unfortunately do not cover tax matters. These covers matters for bail, or these covers matters when somebody is dispossessed of its property. So insofar as the courts are concerned, for tax purposes, there is absolutely no relief. But if there is a taxpayer that wants to get into a difficult situation, then they can still go to the court and make out a case for an urgent matter. The tax tribunals have been a bit more proactive. The tax tribunals have given relief to the taxpayers by hearing matters that concern taxpayers who have been subjected to unreasonable approach by the tax administration. So, for example, last week there was a tax tribunal order passed by its president, talking about the revenue's action to freeze the bank account of the taxpayer in these unusually challenging times, and gave relief to the taxpayer. So that's one aspect that has come to our notice, and we wanted to talk about that. There are a host of related corporate measures and monetary measures which I don't want to talk about, but if you're keen, then I can continue with it. But before I close, I just wanted to talk about some of the important measures that are coming in by way of the OECD Secretariat analysis of the tax treaties and the impact of COVID-19 crisis. These guidances came as early as April 3rd, and these guidances have been largely in 4 categories. Number one, countries to analyze the implications on employment changes that are occurring with respect to employees not being able to meet the 183-day test. Number two, issues that involve cross-border movement of workers. Number three, the impact of constituting a permanent establishment because of the stay of employees or employees engaged in doing work through teleconferencing and finding themselves housed in a particular country. And number four, the suspension of tax recovery proceedings. India has not acted on the first 3 categories of the OECD Secretariat analysis. There have been some discussions with the Department of Revenue who are likely to act on the first 3, but India has acted on the 4th, which is the suspension of tax recovery proceedings, though not administratively, but through the judicial forum. So this is essentially a sum and substance of all the tax developments in India. I'm not talking about the monetary policy stance and the fiscal policy stance or the stance of other regulators such as the corporate law authorities. Let me pause over here and see if there are any questions, and then we can focus on other aspects as well that you may want to raise with me.
Thank you, Mukesh. A really clear and broad overview on the Indian situation. Really important for us. During our talks, we like also to discuss about the future of the taxation, how to approach the next period, balancing the interest of the taxpayers of the economy, which is suffering no way in this period, and on the other side, the interest of the state, which need to collect money and to go on with its normal life to protect the economy. We know that you draft a paper, a document on the future of the Indian situation and in international context as well. So if you have time, you would be glad to have a short overview of this document, which is really, really well written and important for the context. Thanks.
Well, I think it's more of a vision document. People love dreaming, so do I, and that's why I have a tax dream for India as well. And what I have essentially mentioned in this document is let's look at some of the challenges that we currently have in our system. And those challenges are far more profound in the COVID-19 environment, because if we are able to deal with those challenges effectively by way of signaling a policy stance which is seen as more business friendly, investor friendly, then we will be able to deal with the post-COVID crisis more effectively. Of course, tax is not the only subject that governments need to look into. There are other subjects as well, but my focus is really on the tax visioning. This document has been divided in a few categories. One deals with the structure of the administration. And in the structure of the administration, what I have suggested is that because India historically has had very high level of tax disputes, how is it that we can avoid tax disputes in the future? So we have said that you have a written code, which is the Income Tax Act. Now you need to draft another code or a policy as to how the first code will be interpreted. And if you read these two documents together, you can reduce the disputes in India. Now, why do I say that? I say that because historically, our code is driven more by principle and rather than by rule. And when you have any principle-driven interpretation, taxpayers need to interpret in one way and tax administration needed to interpret in another way. And that is the root cause of the dispute that we have in India. I'm saying that let's come out with a code that will help us interpret, and in which case we are able to reduce the areas of differences between the taxpayers and between the tax administration. So that's the first overarching recommendation we have. The second recommendation is that our law and policy stance in the past has been to allow all forms of tax holidays and tax exemptions, which when you sit and interpret becomes very discretionary in nature, where the taxpayer feels he's entitled to the benefit and the tax department feels he's not entitled to the benefit. And as a result of that, both of them are locked up in litigation for years. So I'm saying take away all the exemptions, moderate the tax rate. That's the second broad recommendation. The third broad recommendation is that our tax rates mechanisms have become very complex. We have a plethora of tax rates applicable to corporates, partnerships, corporates that are claiming tax benefits, corporates that are not claiming tax benefits, so on and so forth. I'm saying rationalize the tax rates, put the taxpayers into broad categories of taxpayers. Individuals, small and medium enterprises, large enterprises have a 5 basis point less tax rate for small and medium enterprises as compared to large enterprises. Take away all the tax exemptions. So that's the third category of recommendation that I've given. Now, when you're doing all of this, take away all the specific anti-avoidance measures and take away all the general anti-avoidance measures, because you already have, you don't need a law to invoke specific and anti-avoidance measures. India has very rich jurisprudence insofar as applicable of the judicial doctrine on general anti-avoidance is concerned. So we can use those doctrine in exceptional cases. So these are some of the overarching recommendations on the visioning. Now, how are you able to achieve this? You will be able to achieve this by making sure that the energies of the tax department are diverted in the right direction. So I'm saying let's promote a cooperative compliance program. And in the cooperative compliance program, the taxpayer and the tax administration sit on the table and talk on an equal basis, where the tax department treats the taxpayer like a customer, like a client, and not like a citizen which has to comply with the tax law. But and we kind of completely unclutter the current machinery of people, of additional commissioners, deputy commissioners, and assistant commissioners and commissioners. So I'm saying that of all the taxpayers who fall in your highest bracket of taxpayers, 100 companies, 200 or 500 companies, these are your large taxpayer. Each taxpayer should be given a commissioner rank person for the cooperative compliance program, where they will work with the tax departments of these large companies, help them comply with the law, help them clarify the nuances associated with the law. If there are differences of views, then help them compromise and settle those disputes. And only very, very exceptional cases then go for dispute before the court. So a substantial part of the tax department's machinery, comprising of additional commissioners, deputy commissioners, and assistant commissioners and commissioners, will be allocated to fulfill the cooperative compliance program, and the level of officers that will be allocated will depend on how big is the taxpayer. Now, we as a country also need an assessment or an enforcement function. So we will have an assessment and an enforcement function, but the number of people will be very less in that category. Currently, maximum amount of people are in the enforcement. Maximum amount of people are in the assessment. Okay, now by reorganizing the tax administration and by implementing the cooperative compliance program, you will have less number of taxpayers in the enforcement. Okay, and then we will have also dispute resolution mechanism. This dispute resolution mechanism will work like a compromising committee. This compromising committee will work under the cooperative compliance program to help taxpayers to settle the dispute. And only exceptional disputes will go to the courts for adjudication. And by doing this, by reducing the tax rate, I have no doubt in my mind that in a country like India, which is undertaxed, which does not have sufficient taxpayers because we have the parallel economy going, there will be a degree of trust that will build up between the taxpayers and the tax department to shore up the compliance. And as a result of the shoring up of the compliance, the economies of the scale and the buoyancy in the tax collection will more than make it up for the giveaway because of the reduced tax rate. And I am trying to advocate a philosophy that this is just the right time to relook at your tax policy and build an unparalleled trust with the taxpayers, which historically has not been there or it has been inadequate.
Thanks a lot, Mukesh. You have a dream, so as you told. So
We all have a right to dream.
Yes, we have to.
Yeah. But that's fantastic. I think that also in Italy we should have the same dream. We are on the way of the cooperative compliance. I think that we need to a long way in front of us. I do like the concept of clients instead of taxpayers, due to the fact that the economy, if you have a good administration trying to be fair and helping the taxpayer in paying taxes in the right way, you can have an increase of the economy and an increase of trust of the taxpayer in the administration. So I really like your approach.
Yeah, it's the right approach.
It is a simple economic theory that we are following. I mean, it's first principle of economic theory that your compliances will improve when you have more trust, and as a result of the improvement of the compliances, more taxpayers will come in, and as a result of that, you're going to just have more better tax collection. I was just looking at some of the architects of the cooperative compliance program, which happens to be Netherlands in the center of Europe, and how the cooperative compliance program has extended to many, many countries. But I'm reminded of a jurisdiction which was perhaps more notorious than India, South Korea. And, the cooperative compliance program, which was implemented in South Korea, has brought in phenomenal changes. I was in a program last year, and we were on a panel with a judge of the Supreme Court of South Korea, and she was telling me, the lady judge, as to how much South Africa has benefited from the cooperative compliance program. I don't see any reason why we cannot bring that in India, and this is the right time to do it.
The problem, Mukesh, is, at least for Italy, that all these procedures and cooperative compliance procedures focus all on one concept: trust. And this is the real problem that we have to put in place this cooperative compliance procedure. So that's the issue, I guess.
Well, all I can say is that the trust is core. It's no different in India as well. And it's core not just to the topic of tax, but in everything that entails relationship between the citizens and the government. It's no different anywhere. But, the beauty is that easy said than done. These unbelievable levels of trust can be built over a period of time. The question is, where do you start? And my point is, we start now.
Perfect. Thank you. Thank you very much for representing us your dream and your document, and this really, really interesting overviews also of web taxation and of the situation in this pandemic emergency period.
Fantastic.
Thank you very much.
Thank you. Bye-bye.
It has been really a pleasure.
Bye.
Thank you. Bye. Ciao. Bye.
Bye.